This is Dr. David Shine, and welcome to Business Law 101. Now, there are additional exceptions under the Uniform Commercial Code. Merchant-to-merchant confirmations do not need to be in writing. Number two, specially manufactured goods. Now, this is a particular hot spot for me, and I think I've mentioned already that I worked with a manufacturer, a custom machine shop that made some rigs to go out onto a drilling site, and they didn't get a deposit. The company took the merchandise, the buyer took the stuff, the rigs that were made, and then never paid anything. And I kind of chided the company that came to me, and I said, look, if you're making specially manufactured goods, you should be getting a half or 2/3 up front. You shouldn't make this stuff until you've got some money in hand, and maybe have the other third COD, cash on delivery, when you put the stuff out in the field. And the shame of this is that the company, the machine shop, had provided these materials, these rigs, out to the drilling site. The company never paid anything for it, and then they were sent a series of demands by the company, but not an attorney demand. And then they finally got fed up, and 8 or 9 months after they delivered this stuff out in the field, they came to me, this about 3 years ago, and they said, we'd like you to send a demand letter to this buyer. So I did that, and lo and behold, about a week later, we get back a notice of bankruptcy that the company either triggered by my demand letter, or they had already had so many demands that they'd already sought the protection of the bankruptcy court. They then went ahead and said, well, here's what we're going to do. It went to bankruptcy court. Now, what I did for the client, because I felt bad that they had filed this thing up so badly and were losing so much money, is I took them off the clock and I said, look, I have a bad feeling about this one. I don't think you're going to get any money from this company. I said, so let's do this. I'm going to take you off the clock. When the bankruptcy stuff comes in, I'll take a quick look at it. Most of it is going to be administrative stuff, and it's not going to be very exciting. Certainly, we've filed your notice of claim, but that's about all that you're going to do. And lo and behold, about 18 months later, and probably 30 useless notices from the bankruptcy court, we got a notice that the bankruptcy had been concluded and there was no money being paid to these unsecured creditors. So again, that kind of prepares you a little bit for our upcoming chapter on bankruptcy, but part of the bitter reality. So special manufactured goods don't require a written agreement, but my deal on that would be, A, I would certainly do a written agreement, and B, I'd certainly get a piece of the action up front before I made anything for somebody. So just some things to think about. Obviously, if you admit to the existence of a debt in a judicial proceeding, a deposition or testimony in the courthouse, that is going to be sufficient. And then we've already mentioned our friend partial performance. And again, I would really indicate that most companies today seem to be pretty astute on this. I know when I order custom things, a lot of times we're paying more than half, or we're paying even 100%. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.